SJC-13921, DiZoglio, State Auditor versus Ronald, Mariano, Speaker of the House and others, Attorney General, Intervenor.
Okay, Attorney Sturman. Welcome back.
Thank you. Good morning, Your Honors, and may it please the Court. Ann Sturman, Assistant Attorney General, here on behalf of the Attorney General, and with me is First Assistant Attorney General Pat Moore. We are here today because instead of working with the Attorney General, the State Auditor chose to violate clear statutory and case law when she filed an unauthorized lawsuit against the legislature. There is no dispute that she did so without the Attorney General's authorization, and none of the post hoc justifications that she offers alter that fact. This court should follow the plain language of Chapter 12, Section 3, and this court's longstanding precedents in Feeney, Secretary of Administration and Finance, and Alliance, and strike the complaint. For good reason, the legislature has invested the Attorney General with the authority and the obligation to control the legal policy of the Commonwealth. Longstanding
What does a state official do when, after more than a year of dialogue with the Attorney General and providing answers to questions legitimately asked, there's no resolution by the Attorney General as to whether they will or will not represent the state official?
So first of all, to quibble a little bit with some of the premises of that question, there has not been more than a year of dialogue because at some point the auditor essentially
How long
stopped
has the
engaging.
dialogue been going on?
So
When did it start?
The request that is currently the subject of the request to litigate was from, I believe, January 2025.
Okay, and now we are in what month?
We are in May.
2026.
Yes.
So for that long, this dialogue has been ongoing. What is a state official to do when the Attorney General's due diligence, which is legitimate, I completely concede that, leads to no resolution in terms of whether the Attorney General will appoint a special assistant Attorney General, conflict or otherwise, to represent the state agent?
So I disagree that the dialogue has been going on since January because as of the end of March of 2025, the dialogue had essentially ceased.
So
But
all of
even
this
assuming-
correspondence that happened after March 2025, you think is not part of that dialogue?
So you'll note that there's a large gap in correspondence, Your Honor, between the end of March and August of 2025. You'll also note that subsequent to August 2025, the correspondence focused on sort of ancillary issues like...
Oh, I don't really want to get bogged down in how long.
Sure.
Let's just say it's been a while. Can you agree to that? It's
Sure.
been a bit. Since January
been some
2025, there might have been bits and starts and whatever. There's been some dialogue for a while. What is a state official to do in that circumstance?
State official is to do what the Secretary of Administration and Finance did in that case, which is to bring a claim for declaratory judgment that the Attorney General has been arbitrary and capricious in exercising her authority to control the state's legal policy. That's not what happened here. The auditor chose, instead of teeing that issue up properly before this court or another court, to simply declare herself done with the conversation and file the case that she had not been given permission
So
to file.
as a practical matter, now that the Attorney General has intervened and filed the motion to strike, what's the difference between that posture and what is the limited question before this court?
Between the posture of had she brought a claim that the
Right, aren't
General
we
acted
now at the
arbitrary and
point of needing to figure out whether the Attorney General can stop this litigation from going forward or not? Isn't it effectively the same as a declaratory judgment in Secretary of Finance?
I think that's sort of a dangerous road to go down, Your Honor, because that sends the message to the extent that this court were to indulge in that analysis, that would send the message to every state official that they get to decide when they're done with the Attorney General's due diligence process, whether it's after a year and a half or 2 months or not at all, and simply get their ticket to court by filing the lawsuit that they haven't been given permission to file.
Is there any what's left in the due diligence?
What's left of the due
What are the outstanding questions that the Attorney General needs answers to before it can make a decision as to whether or not it will represent the state auditor?
So there's, let me split that into two, because there's actually two questions. There's the question of representation, but before we even get to the question of who represents who, there's a question of, do we authorize litigation to go forward? Because one possible answer here is that the Attorney General could authorize the auditor to proceed with litigation and not represent either party. So those are, in theory, two different questions. There are substantive questions that remain as to the scope of the audit and the scope of the documents that the auditor is seeking.
What about the three topics that have already been delineated since January 2025?
Those have been delineated.
And they're actually in the complaint.
What has also been delineated is a desire to proceed with what the auditor could not pursue as a part of her earlier audit of the legislature, which was far more broad. And the Attorney General has asked those questions in an effort to not, to avoid a situation where we have serial litigation before the court, where—
So let's just assume it's the three topics that have been identified. What other outstanding queries does the Attorney General have for the state auditor?
So there is also a threshold question, which is that last October, when the Attorney General's office essentially asked the auditor's office, listen, if we authorize a lawsuit within certain parameters and we authorize you to have a special assistant attorney general pursue that lawsuit within certain parameters, will you agree to abide by those parameters? And the answer was no. So in order to—
Where was that answer given that the state auditor said, I will not agree to abide in the litigation that you authorized pursuant to a SAG, a limited scope to these three topics?
That's on page 227 of the record appendix. And the way that that came up is in the course of the correspondence between the parties. We, on August 4th of 2025, in correspondence to the auditor, said that were a SAG to be appointed to pursue litigation on your behalf, any such appointment would be expressly limited to a particular cause of action against specifically identified defendants. And that's not unique to this case, by the way. That's how it works in every case of affirmative litigation. And we asked for a commitment to abide by the scope of that authorization were it to be granted. And the response we got was that the auditor would not make a, quote, blind commitment to abiding by the scope of SAG authority and or assent to the intervention of the Attorney General should she stray outside the bounds of the authority that were granted. So we have sort of two buckets of questions, right? We've got the substantive questions in trying to tee this up as best we can for a court to avoid protracted and serial litigation in which a dispute between two parts of state government is aired in our courts. But we've also got the threshold question of if and when we authorize such a lawsuit, which, by the way, we've represented in our briefs and all the way through that we are more than willing to do once we advance the conversation.
What have you said you're willing to do? That's one thing I can't figure out, because there are three targeted requests. I understand the point you made about they may not be a commitment to abide by those three requests, but there are three particular requests, non-disclosure agreements. I can't remember the other. The third one I'm not familiar with at all, but—
Balance forward line item.
Yeah, what does that mean?
I believe that's, well, I'm not a legislative expert, but I believe that's money unspent from the prior year that then rolls forward.
Okay, so you've got three pretty precise requests. Can't we, and ultimately you two don't get to decide to leave it in limbo indefinitely, because the people have an interest in having that resolved, and this court ultimately decides whether that's constitutional or not you, right?
Right.
So how do we push this to resolution so the people get at least a determination whether that's constitutional or not? Those three items.
So the challenge is that representation, that what they're seeking is those three or four items, has been wildly inconsistent over the course of the—
But let's say we agree with you, but we say, look, those three items we need to make progress on. You're both battling each other to exhaustion and we're going nowhere. But don't we have to push that forward? And isn't that something we can do?
I don't think that that would be an appropriate path for this court because
Making you two resolve what the case is about so that this court can decide whether it's constitutional or not? We don't have any say over that?
unless you find, and this, as I said, has not been properly teed up before the court, the only question that has been reserved and reported today is the motion to strike the complaint. But putting that aside, if you were to move on and examine the question of whether or not the Attorney General's conduct has been arbitrary and capricious.
Oh, but it's, in that case, at a certain point, this court decides whether something's constitutional, not the AG. The AG decides on defense, but you can't indefinitely prevent this court from deciding a constitutional question, can you?
And that's not our intent.
But that's the effect.
It's only the
That's the practical effect, because although you mentioned that this might, in your view, be a squabble between two different parties, you're leaving us out. In the effect of it effectively prevents any court from passing on the validity of the statute. And doesn't that make that part, the part that leaves us, or is it essentially freezes us out until you guys or the AG figures out what she's going to do, isn't that, I guess, qualitatively different than ordinary discretion cases for you? Because of the part that we still get to pass on the constitutionality of it.
Except that it's only been dragged out because of the conduct of the auditor. The Attorney General.
But both sides have dug in.
Right.
I mean, I don't accuse you as one of the amicus of a rope-a-dope, but you both are sort of stuck and not moving. And the people are waiting for an answer.
I mean, listen, if that's the path that the court chooses to take, the Attorney General is an officer of this court. We will abide by the direction we are given by the court. But I don't think that question
that's not
is properly
controversial,
before the
though,
court.
because judges do this all the time, right? So parties parties don't agree. You can be a district court, superior court, whatever court you happen to be in. The court says, go out and work it out. You go out and talk about it, and come in with an agreement that works out your issues.
So two things. First of all, they do that when there is a properly presented case before them. And as I've said, I don't think the question of the Attorney General's conduct is properly before this court.
Well,
but even putting
you
that,
say that, but you're making it seem as if that's the only vertical within which the auditor could proceed, just because that's the way that other parties before her had done so by bringing a deck action. But that we've never said that's the only way that the conduct can be challenged.
you've also never said that a state official, when she decides she's done talking to the Attorney General, can just unilaterally file the lawsuit that the Attorney General has not authorized.
May I ask you a couple of practical questions?
Sure.
In the ordinary course, when the Attorney General has made his or her decision, and that is communicated to the agency head, what happens next? And let's say that the decision is, we don't think you can bring this suit, we're not going to take it on. What would you then do?
So typically, so there's two versions of that answer. There's, we don't authorize that suit and we won't, and therefore I guess the question of representation is immaterial. Or there's, well, we're not going to represent you, but we think there's a good faith question that you're entitled to bring before the courts, and so we'll authorize you to do so through.
So that's where I get stuck, because the AG hasn't decided for whatever reason. I am not blaming the AG, I'm not blaming the state auditor, but there hasn't been a decision, yet there is this statute that permits the audit of the legislature, and the three topics, let's just say they've been agreed to, or at least they've been identified as the limits of what the current complaint is about. Why, on that topic, what's the AG's position? Is there no legal merit to the auditor's position? Or or you know, are you in that camp, or is it just that there may be legal merit, the AG is just not willing to represent the auditor? Which one is it? Which camp is it?
So I think our position at the moment is that there may be legal merit as to some of it, or if not legal merit,
As to those three topics.
at least a claim that ought to be put before the courts to decide.
So you could go forward with those.
But it is also within the Attorney General's discretion to determine how those questions are teed up for this court, so that we're not having one case about those three requests, and then in 6 months, we're before the court again on follow-up requests.
Why do we have to determine the extreme full extent of the statutory authority of the state auditor under this mandate by the people? Why do we have to have that case? We usually don't decide cases that big. We decide the very narrow cases that are with us. And to the Attorney General's credit, at least as I read the correspondence and as I read your brief, even here, those are the three topics that have been identified. So why can't we decide as to those three topics, whether there's legal merit to that or not, whether the legislative privilege prevents it or not, whether we have the power to mandamus the legislature, all of those kind of constitutional questions as to those narrow issues. I don't understand what the AG's unified legal policy is against bringing that forward.
So yes, this court or another court could pass on those questions.
No, I'm not asking you what we could do. I'm wondering what the AG's policy is in preventing those three issues from coming forward. Why not?
The AG's policy, as articulated in our brief, is that generally we try to resolve interbranch disputes.
Right, and
parts of
it's
state
been a
government.
while. These questions have been out there. These three topics have been identified. You say not nearly since January 2025. As I read the correspondence, I come to a different resolution, but it's been a while. And there hasn't been an amicable resolution. I'm assuming the AG is working with the legislature. I know the AG has worked with the state auditor. There hasn't been an amicable resolution that prevents this issue from coming to where it needs to be decided, which is usually the judicial branch.
There hasn't been an amicable resolution, but that is not the end of the inquiry. First of all, in order to determine the nature of the dispute that still exists between the parties, that's in part why we've been asking for the auditor's position on issues like legislative privilege.
And well, I'll ask the state auditor, but it seems to me that she's taken the position that it's these three issues, these three topics.
She has most recently,
and since January 2025, it's in the correspondence from January 2025. It's there. The three topics are there. It's in the audit request to the legislature. There have been statements, I'll grant you, that have questioned whether she's actually limited to the three, but the three have been identified.
Well, there have been more than statements. There's a representation in their brief to the effect of this is where we start, but we're not promising this is where we end. And by the way, we're not asking for a commitment that here's a list of documents we want and we'll never ask for anything more. We're asking for a good faith engagement with the question of what do you reasonably foresee needing right now?
Can I shift you to another part of it, which is my sense is you're focused very much on the mandamus issue. When I read through all that correspondence, you've got the three, whether you're going beyond the three questions, and I understand why you're concerned, because you don't want to let them go out and litigate and start and then try to go beyond that. Although I assume you can limit what they can do. Is that right?
Well, the way we would limit what they can do is by granting the SAG authority within certain parameters, which they've told us they won't promise to abide by, and then we'd have to intervene.
But you litigate it, you decide to represent them and limit it to those three issues and refuse to do anything more. That's even
right.
simpler. But let me take you to mandamus, because I understand that's much more complicated. That you don't believe that you raise questions whether there's the power to issue a mandamus against the legislature. And I get that. But there are also cases that you cite in your brief that we basically say, let me just read. We basically say we expect the legislature to comply with a decision of this court, even without a mandamus, right? I'm just looking at the 436 Mass 144 campaign and political finance decision. And we basically say that we expect the legislature, once we've issued a decision, to comply with it, even if it's not a mandamus, right? We've issued decisions to that effect, right?
Yes, if it is in the nature of orders with which the legislature can be expected to comply.
So the Queen election case, those were cases where we said that mandamus was available? Because we make this point in at least 2 cases, right?
Yeah, I think that, are you referring to Bates, Your Honor?
Yeah, I'm referring to Bates and in the case that Bates relies on.
I don't have the text of Bates in front of me, Your Honor, but I have no
Presumption,
reason.
here's the key language. The presumption exists that the Commonwealth and its officials will honor their obligations. And wasn't that done in a case in which mandamus was not available? I thought that that's Chief Justice Marshall's point, that we expect them to live up to it even outside. Maybe I'm misinterpreting that case, but I thought that was outside of the mandamus context. But I think you're getting a rescue from over there. So.
Here's my lifeline. So that's about the legislature appropriating funds to satisfy a judgment. It would defeat the case law that says that the legislature can't be subject to a mandamus order if you could just issue it as something else and expect the same compliance.
Isn't that exactly the point here? You couldn't compel the legislature to do something, but you expect the legislature to comply with the law, right? Isn't that what we said in that case?
You do expect the legislature to comply with the law, absolutely.
So why isn't that something that you can be comfortable with? You know, I'm not saying you're going to give us a decision on your merits, but do they have a good faith argument on these 3 points that justifies going forward? I understand you're uncomfortable and they're not committing to other things, and this may not be possible right immediately, but those 3 issues seem confined, and it doesn't seem to depend on whether mandamus is available if that case is on point.
So even if we agree with all of that, I don't think that's the question before the court today. And if the court goes in that direction,
What do you think the question is?
I think the question is whether or not the complaint ought to be stricken.
Chief, may I ask a question? One of the suggestions in your brief, as I understand it, is that the Attorney General would be open to some kind of order that required the parties to do something further, I suppose, to try to reach a resolution regarding how to proceed. What would such an order look like in your view?
So an order could say the auditor has to answer particular questions or provide requested information by a particular point in time, and the Attorney General ought to make a decision, either yes or no, in a particular period of time after that. In order,
Perhaps, would it not make more sense, given how the correspondence has gone so far, and I think we've probably all dealt with clients with whom there's a communications breakdown, that maybe the AG identify what it would be willing to proceed with, rather than continuing to ask the same questions and continuing to get the same kinds of responses where there doesn't seem to be any ability to move forward from that tango. Perhaps.
if that would assist the court, we can.
Well, no, I
endeavor
mean,
to do that.
I can't imagine an order really where we would micromanage to that degree. So the question is, what would the order say? In other words, it is hard for me, looking at the history of correspondence, to think that an order might be useful if we're just going to repeat the same cycle of unproductive communications. It seems to me perhaps that a deadline would have to be set by which the Attorney General would fish or cut bait, to use, common phrase. Is that the kind of thing that you see as being reasonable? And if so, what date would that be? What kind of date would we impose? I mean, courts do impose such dates. What would be a reasonable amount of time?
I don't think it would require a lengthy period of time.
A month?
10 days?
30 days, yeah.
Okay.
You know, I want to be clear.
And then what happens at that? So can you play that out for me? We say, order, Attorney General has to fish or cut bait within 30 days. We would find some other phrase for fish or cut bait. And then the parties would file a report just saying, or perhaps it would only be the Attorney General who filed a report saying what it is that the Attorney General had decided, and then we would wait to see what happened, correct? I mean, would the underlying complaint here, whatever the Attorney General's answer is, still be struck because that complaint was not crafted with the input of the Attorney General, correct? So the next complaint would either be crafted with the input of the Attorney General or with whoever counsel is, whether it's a SAG or some independent counsel, but it would proceed in some other fashion. That's what I'm thinking that might be what the mechanics of such a process would be.
I think that's right. I think that assuming we get to where the Attorney General has, the point the Attorney General has been trying to reach, which is that we can authorize something to go forward, that could be accomplished either by striking the current complaint, substituting the new complaint, amending it to conform to the parameters of the Attorney General's delegated authority. It doesn't necessarily have to be a brand new case. But I think at the end of the day, what needs to happen is that if the Attorney General authorizes a complaint within certain parameters, then that becomes the operative complaint in the case, not the one that is before the court today.
What's wrong with the current complaint? I mean, other than it wasn't authorized by the Attorney General.
Well, that's
But
a
in
biggie.
terms of sum and substance of it,
It doesn't state a cause of action. And it wasn't authorized. I don't know that those are the appropriate defendants against whom the Attorney General would authorize a claim were she to authorize one. And so, you know, typically what happens when an agency comes to the Attorney General seeking permission to file affirmative litigation, often they come to us with a proposed draft complaint, and we go back and forth about what that complaint looks like. Even when they don't, or when the Attorney General is not going to represent, we might grant them the permission to file a complaint subject to our review of the complaint. And we go back and forth about, are these the appropriate parties? Are these the appropriate causes of action? Are the facts laid out sufficiently to pass, you know, Rule 11?
Is this further complicated? Is it further complicated by the fact that we got three parties here? We have the legislature as well, and you're also involved with the legislature. So that does make this more complicated, right? Because you may be representing the legislature in this as opposed to the auditor, right?
We might. I suspect the likely outcome is that we might end up representing nobody, and the Attorney General weighs in with her view of the law that, you know, lies somewhere in between the two extremes of the two parties. Yeah, that is also a possibility. But we can't, it is really difficult to answer those questions until we know what that appropriate complaint looks like.
We can tailor the issues that you have to resolve in this 30-day period. We can provide some construct to that, right? Because again, ultimately we have a law that's not, there's no resolution on.
So I think the answer to that unsatisfyingly is yes and no. I think you can. But what I also think is true is that the Attorney General can exercise her discretion to control the legal policy of the Commonwealth in any manner she deems appropriate, so long as it's not arbitrary and capricious. So if there is some question that we're not on the court's list of questions,
is it an error of law that rises to a constitutional level? That's included in arbitrary and capricious, right? Meaning your non-enforcement of a statute. I'm not saying that's this case. At a certain point, the AG can't decide, I just don't like a law and I'm not going to enforce it, right? At a certain point, it becomes our business. Now, they may have to sue you rather than the legislature, and that may have been the appropriate way of doing this, but at a certain point, the AG doesn't completely control whether a law is enforced in the Commonwealth. There's a constitutional constraint on that.
Well, the AG can control whether or not it is enforced by way of a lawsuit brought by a state official, so long as the manner in which she is doing that is not arbitrary and capricious. She might decide that this is a case, we have limited resources in the Attorney General's office. We are at the moment going to focus on enforcement of this bucket of laws over this bucket. And
that what's
that's a
going on
reasonable
here?
judgment. That's not what's happening here.
Okay.
But I think
So what is the
that would be-
uniform legal policy that's precluding this from going forward?
the uniform legal policy is to prevent, to try to resolve interbranch disputes to the extent possible without help from the courts, and to the extent that we must
Is that,
ask the
is
courts.
that exhausted at this point?
I don't know that it is, because part of the challenge with the remaining uncertainty about what it is the auditor's looking for is the challenge that we have when we go to the legislature and we say, okay, what's your position on that? Right? If we don't have a clear answer on what it is we're asking in that question, then we can't get a clear answer from the legislature. But even aside from that, I also think that there is a clear legal policy within the discretion of the Attorney General to try to, if that fails, and it may well sometimes fail, and maybe this is one such case, to try to tee it up for judicial resolution in the most efficient way possible, right? To avoid the serial litigation to the extent we can. And I think that is a reasonable exercise of the Attorney General's discretion. It is not arbitrary and capricious. This is not a case where, for example, the Attorney General has just refused to engage with the auditor at all, has not responded to her request for litigation. We've asked questions. The auditor disagrees as to whether or not we've gotten our answers. This court may disagree as to whether or not we've gotten our answers, but the Attorney General's reasoned judgment that she has not gotten those answers to her satisfaction is not arbitrary and capricious.
Okay, thank you
Thank you.
very much. Okay, Attorney Lise Reardon.
Good morning. May it please the court. I'm Shannon Liss-Reardon on behalf of the state auditor. With me is Michael Lung-Tat, the general counsel for the auditor's office, and Trevor Byrne. So this case raises the very important question of whether the Attorney General can unilaterally effectively block enforcement of a voter-approved law approved under Article 48 by preventing access to the courts by another co-equal constitutional officer who seeks to enforce it.
Counsel,
Is there a
can you
reason?
be, I'm sorry.
Is there a reason that you didn't first start by bringing a complaint against the Attorney General for not moving forward with this?
Well, I believe, as Justice Wentland pointed out, effectively we're at the same place now. And in the Feeney
No,
case,
that's actually not my question.
okay, sure. In the
Because
Feeney,
I'm asking a procedural question.
Yeah.
Why is it that you didn't begin with that as opposed to jumping ahead?
because there's no legal requirement that that be done. In the Feeney case, this court addressed this type of issue in the course of the underlying litigation. So there's no rule that says that a declaratory action needs to be brought against the Attorney General in order to tee this issue up for the court.
But isn't that the way you should have done it, though? Because the fight is between you and the AG right now on representation, not you and the legislature on representation.
Right. Well, but the issue is teed up because the Attorney General intervened and moved to strike. So effectively, we're here. Now, if you were to say we needed to go back and do that, it will just be more delay before the people get an answer to this question because a case may be brought. It could very well be brought in federal court. We then may need to wait for the federal court to certify the issue.
But as Attorney Sturman brought up, this will send the message that anytime somebody from the executive branch decides, any state agency decides that they don't want to wait and they don't want to go through that procedural hurdle, that they can just do as you did.
No, that's not correct because the court here could cabin when such an action is appropriate. So this is an unusual case. I think all the parties agree.
Are you prepared to do that? Are you prepared? Is the auditor prepared to limit this to the three issues? Because when you read the correspondence, you keep saying, okay, when we do an audit, we can't be bound by what we start with. So are you prepared to limit this to those three issues which are defined for the time being, it doesn't mean you can't bring a separate lawsuit where where we go back and decide this issue again, but are you prepared to confine this to those 3 issues?
Yes, the audit, in the correspondence, the record makes clear the auditor has repeatedly said that this case would be about the document requests that were already served in January 2025. And this court just last week.
I'm being more, because I've read through those. They're not the clearest correspondence on earth. Are you telling this court, because we have to issue some kind of order in this case, that all the auditor is seeking is representation from the AG on these 3 particular audit requests, and the authority to proceed on those? Because that will clarify what we have
And
to do.
if so, can you please be even more precise and say exactly which letter you're referring to?
Yes, I'm referring.
So which audit demand letter?
Yes.
Is it the January 9th letter?
Yes, the January.
So you're going to confine it to that?
The January 3rd document requests and followed up by the January 6th specific transmittal of the document request. The state auditor has repeated throughout the correspondence, this case simply seeks to enforce those requests. Because anything beyond that, the state auditor was aware of this court's jurisprudence that this court cannot answer hypothetical, unripe questions, as this court just affirmed last week in its advisory opinion regarding the public records ballot initiative. The court said, well, the Attorney General completely consistently keeps saying, well, it's the Attorney General's position that litigation should not be piecemeal, everything should be crystallized in one case. This court has specifically said that it cannot decide unripe hypothetical issues. The state auditor has not issued any other document requests. This is about these requests.
The January 3rd letter is the one at Appendix 310?
Correct.
That's what you're prepared to confine yourself to right now?
Well, as it was elucidated in the January 6th letter at Appendix 313, correct. That's what this case is about.
So then there's no problem.
I don't see why there is a problem, because the Attorney General has never even said that it has an issue with those requests. And under Secretary of Administration and Finance, this court said that it is only where the Attorney General believes there is no merit to an appeal, the Attorney General can refuse representation at all.
Can I, just to push back a little bit,
Sure.
Because in the January 6th letter, you expressly, not you, the audit manager, expressly reserves the right to expand those categories and to make future. But that complicates the inquiry that's presented here for now, because if you're saying we're asking for what's in January 6th, then January 6th is an unlimited ask. In other words, it's these 4 things plus whatever we may expand to. That's a different thing. So are you limiting it to just the 4 numbered paragraphs?
Yes, again.
That's it, with nothing else, no reference to expanding it beyond that?
Well, this case is about the 4 asks on Appendix 313, and the auditor has
So those 4 paragraphs
said that
without any potential for expansion?
well, there may be another case.
Another
There is an
case, but here, that's it, just those 4.
For this case, correct.
Can I push you next? Because from
Yes.
what I understand, you've also been seeking that they file some kind of mandamus action. That's complicated legally. Are you insisting that they bring a mandamus action on those 4, or are you prepared to live with something more like Bates? Because that's another issue they may have problems with, bringing a mandamus action against the legislature.
So I have 2 points on that. One is in the correspondence between the parties, the Attorney General itself, the office itself said there may be ways around this mandamus issue. The state auditor, even though they are not the attorney here, the Attorney General is the attorney, the state auditor provided a very thoughtful legal analysis about distinguishing the limits case. But it's the Attorney General's job to figure out the legal strategy
Well,
here.
but they're worried that you're going to make them argue something they consider illegal.
Well, they can decide.
So
Or something that will cause negative consequences in the future. And that's something that is conferred to them exclusively.
But the correspondence wasn't that way, was it? The correspondence was the Attorney General asking, how are you going to get around the limits case? How are you going to deal with declaratory judgment not being available to the legislature? And what the state auditor said, well, I'm no lawyer, but here's what my thoughts. And that's where it stood. And then the Attorney General responded saying, well, maybe mandamus isn't maybe there are ways around mandamus, didn't identify expressly what the ways were. That's the way the correspondence went down, isn't it?
Yes, exactly. And again, in Secretary of Administration and Finance, this court said that only if the Attorney General finds no merit to the appeal can representation be denied altogether.
The state auditor's position is not that the SAG, if one is appointed, must bring a mandamus action.
The state auditor was asking the Attorney General, as prospective counsel, let's discuss how we can do this. Let's discuss what the best course of action would be, and here are some ideas about how mandamus can be achieved. The Attorney General basically said, yeah, that might work, but then continued to ask the same questions over and over again, including what kinds of action do you plan to bring? It's very clear from the correspondence that the Attorney General was simply stonewalling the efforts. By never saying no, the Attorney General can stand here before this court and say it never said no. But in the course of more than a year, it clearly said no because it did not permit this voter-approved law to ever be enforced. And in so doing, the Attorney General has effectively usurped this court's role in deciding constitutionality of the state's law.
I don't see that. I don't see that at all, to be frank. The fact that a party and its counsel decide for whatever reason not to bring a suit to the courts does not mean that they have thwarted the court's authority to decide issues. The courts wait for the issues to come to them. So I would like to go to the question of a potential order. I take it that if you are prepared to confine yourself to these 4 numbered paragraphs in the January 6th letter, then the only thing from your perspective that's remaining is to see what allow the AG to come to a final conclusion with respect to those within a reasonable period of time to be determined by the court?
Yes, the state auditor would have no objection to that. We take the position that the Attorney General has already said no through her actions. If the court wants to hear an actual NO from the Attorney General,
or it may be a yes, or it may be a yes and no.
It may be no to you when they're going to do it themselves, or maybe it's yes to you and they're not going to do it, but we don't have an answer.
Right. No, the state auditor would welcome a definitive answer from the Attorney General so we can all know how to proceed. Because effectively what the Attorney General has done here is by claiming that the law allows her ultimate and complete gatekeeping authority, this is thwarting not just the state auditor, but...
You're overstating their position.
Yeah.
Yeah, I mean, I think that the correspondence has been less than linear, having spent a lot of time with it. There's been identification of these 4 issues. There's been a statement that, no, it's not just these 4 issues. I'm starting here. There's been, statements back and forth about the legal causes of actions. And then there have been statements made in the public. So, it's not true that the Attorney General has stonewalled this case. There has been correspondence back and forth. And I think we're at a point where if you are willing to live with, and you are willing to live with these 4 topics, and that's it in this lawsuit, we give the Attorney General 30 days to determine the scope of the complaint that she is willing to bring or not willing to bring.
The
Or
state
she's
auditor...
willing to allow a special Attorney General to bring.
Yeah. The state auditor has repeatedly said in the correspondence that this litigation would be limited to those 4 issues. So there's nothing changing here about that. Now, if we're going to get outside the record, the Attorney General has made clear...
So there's been reference in the record to things outside of the record. That's only the reason I said anything.
Right. The state auditor has said one day there may be other things, that would be another case. The state auditor has repeatedly said in answer every single time asked This case would be about these 4 issues. That is all that is ripe. That's all that's present. That's all this court could even opine on.
Well, I think this exchange underscores part of the problem with the posture that the filing of this suit has put the court in. Ordinarily, we are not supposed to be sitting here interpreting a series of correspondence between a client and its attorney before any litigation has been filed to determine what they're each thinking. I'd like to turn to your actual complaint. It doesn't name the Attorney General, and it also doesn't identify any causes of action. What are the causes of action?
The causes of action, I mean, the issue before this court right now, obviously, is whether this case can even proceed. Can it be amended if necessary? Sure, any case can be amended, but because there is, one might say, some ambiguity in this court's jurisprudence regarding what cause of action will get the results that the state auditor is looking for, the current complaint is broad. It's simply seeking enforcement of the law.
It doesn't identify a cause of action.
Well, it asks for the law to be enforced. That
It asks for relief, but without a cause of action.
Okay, but again, the question of whether or not this particular complaint is suitable or not is not the basis for the Attorney General's moving to strike it. The Attorney General has moved to strike it, and this court has taken up the issue simply of whether that motion to strike should be granted or not. So getting into the legalities of the underlying dispute is what we're happy to do, or whoever is arguing.
But I think what the Attorney General is the point the Attorney General is attempting to make is that the deficiencies of the complaint underscore why it is premature, because there's been no input by the Attorney General or another, or SAG or whatever, in crafting the complaint in a way. And so it's sort of like a premature birth. It's just come here without the process that should ordinarily occur before such a document is filed.
There was nothing stopping the Attorney General over the course of this year to actually engage with the state auditor in crafting what a complaint should look like. The state auditor went to the Attorney General as its potential counsel and basically said, we need to bring this case. Let's bring this case. The Attorney General's job under the law, the law that the Attorney General must follow is A, it must enforce the laws of the Commonwealth, B, it must enforce the public interest, which is clearly stated here. The Attorney General never
we have a statute. I mean,
tried to block this.
To simplify it, there's a statute passed by an initiative that says you can audit the legislature. Now, that parts of that statute may be unconstitutional, the whole thing may be unconstitutional, I don't know, but your cause of action is the statute is being violated because the legislature is not complying, and we're asking you to enforce it, right? That's what this basically comes down to.
Yes, and whether you want to call that mandamus, declaratory judgment, I mean, that's something to be gotten to in the underlying dispute. But the point is that the Attorney General never played the role of the attorney for the state auditor to figure out how to enforce the state's law. And in so doing, the Attorney General is it's not just a question of thwarting the auditor, it's thwarting the people, because under Article 48, the people have a co-equal right to make a law with the legislature, and that is what they exercised through the ballot initiative process in 2024. The Attorney General has an obligation under this court's precedent to not engage, not to block action in a way that is arbitrary, capricious, or unlawful. It's not just arbitrary or capricious, it's unlawful. The reason the Attorney General's actions in not allowing this case to move forward is because it is unlawful. Under the law, the Attorney General must enforce the law of the Commonwealth. If the Attorney General does not agree with that law or finds it repugnant, the Attorney General can appoint a special Attorney General, and then the Attorney General can take whatever position she thinks is best, but she can't simply not let it get to the
They have a little more power than that. They have the power to control litigation and sometimes not bring litigation. So they may be exceeding that power here, but it's not just simply they have to do something. They make decisions. A law may be unconstitutional and they're not going to enforce it. They do that and they tell state government regularly, you're not going to be able to do this. So it's much more nuanced than you're making it out to be.
Yes, Justice Kaffer, I agree with that. What I'm saying, though, is that this is not a run-of-the-mill dispute over some arcane dispute over statutory interpretation. This is an important constitutional issue in which, again, if the Attorney General thinks this law is unconstitutional, then the Attorney General needs to appoint, or this court needs to appoint, separate counsel to defend the law. The Attorney General can then take whatever position she wishes in court. But again, blocking this issue from even getting to the court gives the Attorney General this super authority over co-equal constitutional officers. The auditor has her own statute that allows her to enforce her responsibilities and her duties, and the Attorney General is thwarting that if she doesn't allow this case by some means to get to this court. So this court has the power under its authority, under its precedent, to either order the Attorney General to allow this case to go forward with a special Attorney General or appoint separate counsel itself.